Okay. Shall we start? Shall we start? All right. Good evening, everyone. This is Anshli Joshi, and I am representing lawupdates.in today. I would like to welcome you all in today's session. So today we have with us Advocate Bhavna Kapur, who is a practicing advocate in Punjab and Haryana High Court since 2017, and also National Certified Capital Market Professional. She's also an associate in Kapur law firm that was established in the year 1925. Her expertise includes rent matters, property disputes, writ petitions, arbitration and ADR, motor accident claims, consumer legal services, and criminal complaints. Apart from these things, she's also legal aid counsel for the High Court Legal Services Committee, Chandigarh. Apart from these things, she is also successfully handling the matters regarding the She's also active at the District Court Chandigarh, State Consumer Dispute Redressal Commission, and various other tribunals. Being passionate about the public speaking, she also runs her own literary club on the name of the Orator Guild. She will be speaking about the topic Consumer Protection Act, the latest amendments, and its impact on consumers. And one more thing, I have a small announcement for all the attendees that they can ask the questions in the chat, and these questions will be taken up by the ma'am at the end of the session. Now, we'd like to invite Advocate Bhavna Kapur to start today's session. Over to you, ma'am.
Thank you so much, Anjali, for such a wonderful introduction. And I hope I'm audible to everybody. And thank you for having me here, Law Updates. So today's session, I think Consumer Protection Act is one topic which is not just helpful for people from the legal background. Say, for example, you're a lawyer, or say, for example, you're in the law school. I think this is one topic that is going to be beneficial for everybody at large. So not just for consumers, manufacturers, sellers, everybody, because the new act has brought up a whole lot together, a lot of things. So this session, let's just bring it out this way. Even if you're watching it later or even if you're live right now, let's just try to gain maximum out of it. Now, what happened in 1986? We had the Consumer Protection Act of 1986. It is a long time ago. But with the changing scenarios with regards to the rights of the consumers, the liabilities of the manufacturers, we have come up with a new act, which is the Consumer Protection Act of 2019. Now, what I'll do is I'll firstly cover up whatever the 2019 Act talks about. And then what we can do is we can compare the 2019 Act with the 1986 Act, and then we can see how the new Act is proving to be beneficial for the consumers. So what we have is from section 3 to 9, we have the protection councils. Now this stays the same for the 1986 Act, also for the 2019 Act. We have at the central level, then at the state level, and then at the district level. So at the central level, we have a minister in charge, followed by other officials, and they will be holding one meeting every month. After that, we move on to the state protection councils. Again, the format of the number of people who would be appointed at the State Protection Council is similar for the 1986 Act also, and also for the 2019 Act. Then we come to the District Protection Council. So all in all, the whole purpose of these protection council is protection and promotion of consumer rights. And that has stayed same since 1986. Now comes section 10 to 27, which is the Consumer Protection Authority. This is altogether a different concept. It was never there in 1986, and the entire compendium of sections has been introduced in the 2019 Act. Now, under the Central Consumer Protection Authority, we first of all have the Chief Commissioner. He will be heading the Central Consumer Protection Authority. And other than that, there'll be other officials that will be appointed by the central government. And they'll be running at NCR, Delhi. Now, whatever the recruitments are or whatever the vacancies are, they'll be fulfilled by the central government. Now, what is the role of this Central Consumer Protection Authority? You cannot file a complaint there, but they are working as I would say, a central power who would be taking up inquiries, who would be looking after the investigations, who can file complaints before the district commission, state commission, or the national commissions. They can even intervene in the proceedings, review the matters, and they would also be doing other research work. And the purpose of the Central Consumer Protection Authority is also to spread awareness. Now, to run as an association, as an authority, they will be appointing number of experts, professionals, and other officials who will be doing the work for them. Say, for example, they're getting some complaint or they want to file a complaint against, say, a commission, or they want to proceed in a certain way. They will be taking the expert guidance from these professionals or the people in that field. Then there'll be an investigation wing. Now, this investigation wing would be working towards, say, for example, they find out that the consumer rights have been violated at any instance. So this investigation wing would carry out a preliminary inquiry and investigation. Now, this would include the Director General, then there would be the ADG, the Director, the Deputy Director, the Joint Director, and the Additional Director. So all of these together would form the investigation wing. Now, the district collector. Now, what is the role of this district collector? This district collector would be inquiring or investigating regarding the complaints with respect to the violation of the consumer rights. So, when I say Central Consumer Protection Authority, they will be working with certain departments who will be providing them certain expert guidance or certain professional advice. Secondly, there will be an investigation wing. And thirdly, there will be a district collector who would be looking after these inquiries and investigations and anything which is violating the consumer rights. Now, in order to fulfill certain procedures, or say, for example, whatever is the function of the Central Consumer Protection Authority, to carry out inquiries, to carry out investigations, to spread awareness, or to promote research and everything, they will be holding certain procedures. Number one procedure, which is Section 19 of the new Act, is to refer the matter to other regulator. Say, for example, after the preliminary investigation, they feel that a regulator is required to look after that matter. Then the matter would be referred to that regulator, and then he will be carrying on the procedure further. Second is recalling of goods. Say, for example, they find out that there is an unfair trade practice, or for example, there is a restrictive trade practice. Then it is well within their scope to recall the goods, to say, for example, withdraw the goods, to reimburse the price to the consumers, to even make sure that they discontinue with this unfair or restrictive trade practices. Third comes the directions or penalties against misleading advertisement. Now, say, for example, they find out that there is a certain advertisement, say, for example, in a newspaper or a television or affecting people at large. They are well within their power under Section 21 of the Act to issue directions or even impose a penalty against an advertisement which is misleading. Say, for example, now, how are they supposed to decide how much penalty is to be imposed? They will look at the area which is impacted. Now, for example, the area which is impacted by the advertisement is very small, then the penalty would be within that range. But say, for example, the area which is impacted by such a false advertisement is affecting India at large, then the penalty would be large. Second way of deciding it would be the frequency and duration. Say, for example, the advertisement could just run for 1 week or 1 month. Then obviously the penalty would be lesser. But say for the advertisement has been running for a long period of time, then in that case, the penalty would increase. Again, it would depend on the gross revenue that the company gained from this false and misleading advertisement, and also about the vulnerability. So these are the certain factors when I say that the Central Consumer Protection Authority has the power to issue directions and penalties against false and misleading advertisements. Third procedure which comes under the Central Consumer Protection Authority under Section 22 is search and seizure. Say, for example, the Central Consumer Protection Authority finds out that certain company is doing certain malpractice, or they are selling, say, for example, adulterated goods. It is well within their power to conduct a search, to look at the place, even to check the inventory, to check the accounts of that very company. Now, whatever they have seized from that search, they have to return that within 20 days after carrying out an inquiry or after, investigating that product or inspecting that product. In case they feel that the product is something which would naturally decay within the time, then it is their duty to make sure that it is also disposed of as quickly as possible. Now, anything or any action which is taken by the Central Consumer Protection Authority, you are well within your right to appeal against that very order, and the appeal would lie to the National Commission within 30 days. Also, the accounts of the Central Consumer Protection Authority will be audited from time to time. The reports shall be prepared and they can be inspected as well. Now we come to section 28 to 41. We have had this as a set of different sections in the 1986 Act, but because we added the Central Consumer Protection Authority, the sections for the District Commission have moved from section 28 to 41. Now, what is happening under the District Commission? We have a president and we have 2 members. Now, this stays the same for the 1986 Act also and for the 2019 Act also. The major difference which I'm going to talk about is the jurisdiction. And this is going to affect the consumers at large. Firstly, if I talk about pecuniary jurisdiction. In the earlier Act, the District Commission had the power to take up the goods which are valued up to 20 lakh rupees. But under the new Act, you can file a complaint before the District Forum or the District Commission up to the value of 1 crore rupees. Which means, say, for example, earlier you had a good which was valued at, say, 60 lakh rupees or 70 lakh rupees. You would have to approach the State Commission because it was over 20 lakh rupees. But now they have extended their the bracket to 1 crore rupees, right? So the pecuniary jurisdiction of the District Commission has gone up to 1 crore rupees. Now, who can file a complaint? A consumer can file complaint. Where can the consumer file a complaint? In the earlier Act, there were 3 places where a consumer could file a complaint. A, where the complainant was residing. B, where the complainant was carrying on the business. C, where the cause of action has arisen. Now, I personally believe that the 4th option, which is added in this new Act, is so beneficial, and it's going to ease up the process so much for the consumers, because the 4th option states that a consumer can file a complaint where he resides or where he personally works for gain, which is all the more good because, say, for example, you purchased a product from Bombay, or the company was working in Bombay, you no longer have to file a complaint there. You can, if you are in Jalandhar or you are in Delhi, you can file a complaint from the city where you're residing or you are personally working for gain. So this jurisdiction part is a new, they have brought in a new agenda in the new Act, which was never there before in the previous Act. Again, when we come to the proceedings and the procedure stays the same, almost the same for the 1986 Act also and the 2019 Act also. Now, what happens in the procedure? Once you file a complaint at the District Commission, the District Commission will decide within 21 days about the admissibility of the complaint. Once the complaint is accepted by the District Commission, the complaint copy is sent to the opposite party within 21 days again, and the opposite party has to file a reply within 30 days, and in rare circumstances that it can extend to another 15 days. The opposite party can either deny the dispute or give a reply to the same. Now, say for example, the complaint consists of something that contains a sample. So the District Commission can take up that sample and send that sample to the laboratory for testing. Then the District Commission will ask the complainant to deposit a certain fee to carry out that investigation or to carry out that sample testing in the laboratory. The fee is taken from the complainant and the fee is then sent to the laboratory. If the parties dispute regarding the findings of the laboratory, they are forward to bring forward their objections and to file the same before the District Commission. Now, the opposite party and both the parties have the right of being heard, right? Once the parties are heard, the District Commission can then give forward their order. But say, for example, one of the parties is not coming up. Then in case the opposite party does not come up, then the District Commission can proceed ex parte or can proceed based on the evidence which is brought forward by the opposite party. Now, in case the complainant does not come up, If the complainant is only not coming up post filing of the complaint, then the district commission has the power to decide it on merits. So all this comes under section 28 to section 41 of the district forum. Moving forward, we have also, before I finish about district forum, the decision has to be taken by the district forum in 3 months. If there is no testing involved, if there is certain testing procedure involved, like sending the sample to the laboratory, and that might take time. So the decision has to be taken within 5 months. Now this remains the same for the 2019 Act also, and for the 1986 Act also. Now, there is another feature which is added up in the 2019 Act, which is the power of review. The district commission has the power to review its own order, and it has never been there in the 1986 Act. Also, any order which is passed by the district commission, you have the right to appeal, and the appeal can be done within 45 days. In the previous Act, the right to appeal was there, but the appeal could only be done within 30 days. So review option is added. The appeal option stays, but there is an extension of 15 days when it comes to the right or the time period for filing an appeal. Now we come to the state commission. Again, state commission would have a president, and earlier there were president and 2 other members. Now there shall be a president and 4 other members. So the composition of the state commission has increased by 2 additional members. Qualification, salary, everything remains the same. Jurisdiction, for the district commission, we have the jurisdiction up to 1 crore rupees. For the state commission, the jurisdiction has increased from earlier for state commission, it was 20 lakhs to 1 crore rupees. Now that the district commission has up to 1 crore rupees, the state commission would have the pecuniary jurisdiction from 1 crore to 10 crore rupees. Earlier, it was 20 lakhs to 1 crore rupees. Again, as a consumer, you can file a complaint from where you are, from within the state you are, because the appeal would go from the district commission to the state commission. The review power is again added. Earlier, the state commission had no power to review its orders. Now the state commission has the power to review its own orders. And the time period is same as the district commission, which is 30 days. Appeal, the period of appeal was same for the district commission. The period of appeal stays same for the state commission, which is again 30 days. Now the appeal should be heard within 90 days. You can file an appeal within 30 days against the order of the state commission to the national commission, and the appeal shall be heard within 90 days at the state commission. So these are the certain things which are added in the state commission. Most of them are the same. The only things that are added is A, the pecuniary jurisdiction, and secondly, we talk about the review petitions. Now comes the national commission, which is covered under section 53 to 73. Again, just like the district commission and the state commission, the most of the functioning of the national commission shall stay the same. Now, when it comes to the pecuniary jurisdiction, national commission has the power to hear the matters where the value of good exceeds 10 crore rupees. Earlier, you could file it when the value of good exceeded 1 crore rupees, but now you can file before the national commission for the goods which exceed 10 crore rupees. Any order of the national commission is open to appeal before the Supreme Court. The limitation period for all the commissions is 2 years from the cause of action. Now, this applies to the district commission also, state commission also, and the national commission also. Now, penalty. In case of non-compliance of order, say for example, you or the opposite party is not complying with the order of the district commission, state, or the national commission, you have a penalty which is going to be imposed on you, which is an imprisonment for 1 month up till 3 years, and a fine which is from 25,000 rupees to 1 lakh rupees. Now, in the previous act, the penalty was 20,000 to 1 lakh rupees, which has now been increased from 25,000 to 1 lakh rupees, which means a minimum penalty would be 25,000 and it can go up to 1 lakh rupees, right? That was all about the state, district, and the national commissions. Almost same, but I've talked about the points which are additionally added. Another important feature which is added is section 74 to 81, which is the mediation cell. Now, never before had the consumer courts had a mediation cell. In 2019 Act, A selection committee has been appointed by the president, which would consist of a president and a member of that commission, to attach a mediation cell to that very commission. Now, this just does not apply to, say, for example, National Commission. A mediation cell would be attached to the District Commission also, State Commission also, and the National Commission also. Now, what is the advantage of this mediation cell? Say, for example, there is any scope of settlement outside the consumer court between the manufacturer, between the seller and the complainant, or between any two parties. They can get the matter peacefully resolved by this alternative dispute resolution system. So, the mediation cell, I would personally feel, has been a very, very important addition to the 2019 Act, because before going to the courts, if the court feels there is any possibility of getting the dispute amicably resolved, then they can refer the matter to the mediation cell. Another important thing after the mediation cell which comes up is product liability. Now, this has never been there before, and this has been added up in 2019 Act. When I say product liability, which means there are three classes of people who would be liable for the product they are selling. One would be the product manufacturer. Second would be the product service provider. And the third would be the product seller. Up till now, the liabilities of these very people were very, very restricted. Now, the 2019 Act has altogether added section 82 to 87, which would talk about the product liability. When I talk about product manufacturer, say, for example, there is a defect, or there is say, a problem in the design, or you have seen a product online, and when you get the product, the specifications of the product mentioned online and what you have received is completely different, or there is no warranty involved, or there has been anything which is false and misleading, then that very product manufacturer would be liable under this very act. When I talk about the second category, which is the product service provider, say, for example, there has been a faulty service, or say there has been negligence on the part of a service provider, or certain instructions were not given at all, or again, there is no warranty. In all these four circumstances, the product service provider would be liable under this act. The third category is the product seller. Now, we all know manufacturer and service providers is a different category. Now, the seller is through which you are directly buying that product. You might not be buying it from the manufacturer. You might be getting it from the seller, right? So when a product comes to the seller, say, for example, the design is wrong, the packaging was not correct, or the product has been modified from what the manufacturer has produced, or say, for example, the seller has not been cautious in assembling the product or inspecting the product, then in those very cases, the product seller would also be responsible. Other than these three categories, there are certain situations where there would be no liability of the product manufacturer, product service provider, and the product seller. Say, for example, the product has been harmed by you during your usage. In that case, we all know we have to be cautious to use the product, but if you harm the product at your own level, or if you misuse the product, then in those situations there would be no product liability. Second, a warranty has been given, but still the product has been used in a different way. So in that case, again, there would be no product liability. Now, certain products mention that the product has to be used in the supervision of an adult or supervision of an expert. If you're using the product not looking after those guidelines, then there would be no product liability. And the fourth case where there would be no product liability is, for example, the complainant was under the influence of a drug or alcohol which has not been prescribed. So while using the product, if certain mishappening or something happens, then in that case, the product liability would not be there. So these are the certain sections which have been completely and newly added to the present act. Never before have we talked about mediation cell. Never before we have talked about the product liability. So all in all, this act is a package which is adding so many powers to the new consumers, giving them so many rights, and which we all need to be aware of through the new act. Then comes offences and penalties. Never before in the previous act there were any sections which talked about the offences and the penalties. Now the penalties are enforced under the following categories. One is non-compliance of directions of the central authority. So we had talked about the sections about the Central Consumer Protection Authority. If the Central Consumer Protection Authority has issued certain guidelines or has passed an order, and the order has not been complied by any of the party, then there would be certain penalties for the same. Second, in case if you're selling any spurious goods, or say for example you're selling something which is adulterated, there would be certain penalties about that. Fourth situation where certain penalties would be involved, and this is very important, would be if a search has been conducted by the Director General in a very vexatious way. So in that situations also, a penalty would be imposed on that Director General who has conducted a search which was not within his scope. So for example, there are chances that they may conduct a search over which they have no right. So they can be penalized under this very section for conducting such a search. All in all, these were the sections that came up in the 2019 Act. Now, how are these sections, or how are the latest amendments of 2020 and this new Act beneficial for the consumers? Now, this Act was passed on the 9th of August 2019 and it was enforced on 20th July 2020. I'm going to talk about the points which is like a crux of how the consumers can benefit under the new Act. First important thing, which I think is a life-changing thing, is e-commerce. E-commerce was never added to the Consumer Act up till now. And especially, I think, during this time of pandemic, when most of our shopping is through an e-commerce website, adding e-commerce platform will, in the preview of this Act, would prove to be very beneficial for the consumers because, see, I believe there are e-commerce websites like Amazon or Flipkart, which always came with instructions, which always talked about warranty, the time of delivery, or they had their grievance redressal commissions and everything, was there for such a famous website or for a famous e-commerce platform. But now, any e-commerce platform that is selling products online would come under the preview of this Act. And when I say e-commerce, which means every e-commerce website has to talk about return, exchange, refund, warranty, guarantee, delivery, shipment, payment methods, grievance redressal, everything. So if you feel any e-commerce website is not following this prescribed format, then you are well within your right as a consumer to proceed against them. Second thing which I talked about was place of filing. Now this again has been very, very beneficial. You can file a complaint from the place where you are residing or you are working for gains. Third important thing here is e-filing. Now, the new Act has brought forward the option of e-filing, which means you can do an electronic filing and even the matter can be heard at through video conferencing, which means you do not even have to go to the court. The entire procedure can be carried out from your homes. So you can get the filing done online and then you can even hear the matter, carry the matter forward through video conferencing. Then I've talked about pecuniary jurisdiction, which has increased from the previous Act. For district commissions, we had 1 crores. For state commissions, we have 1 to 10 crores, and national commission is above 10 crores. Another important thing which is added in this new section is punishments and penalties. Never before have they been talked about in the previous Act, but in this Act, in case you are selling adulterated goods, spurious goods, or a vexatious search has been conducted by the Director General, or an order of the Consumer Protection Authority has not been complied with, then there would be certain penalties that would be enforced on them. Seventh important thing is Central Consumer Protection Authority, which is there to promote the rights and issue guidelines. We've talked about them in detail, and that has been added in this new Act. Eighth important thing, again, which we talked about, was the mediation center. So mediation center would be attached to the district, state, and the national commission. Now, the definition of consumer. When I talk about the definition of consumer, one point has been added in the new Act, which was not there in the previous Act, which was online purchasing. So when I say e-commerce, the consumer would be a person who is making an online purchase also. So this particular instance has been added up in the new Act, which states that a consumer would include an online purchaser as well. Then comes express warranty. When I say express warranty, which means, again, every website or any e-commerce platform or even any seller in general, any manufacturer in general has to talk about express warranty, which means whenever you are selling a product, you have to give a warranty along with that. That may be any period as per the company, but the express warranty option has to be provided. Now, if under the new act, any form of association can also file a complaint. Another important thing which is added in this act is incidental losses. Now, what are incidental losses? Say, for example, I am a consumer. I applied to a certain university which issued a misleading advertisement, and based on that misleading advertisement and applied to that university, I got my degree done, I got the certificate, and I later found out that the value of that degree is not what the advertisement talked about. Now, I can file a consumer complaint. When I file a consumer complaint, I would not only just be paid, like in the previous act, we were paid for, say, mental harassment or any other form of losses or damage. In this very act, we will even be paid for the incidental losses. Say, for example, in this very example, I will still be paid for things like my year got wasted, my 2 years got wasted, or the education did not prove beneficial for me in any which way. So such different categories are incidental losses, and the new act would cover those losses as well. So you would not just be paid for something in which your money has been spent or you're mentally being harassed, but even if your time is wasted in a certain way, such kind of losses would also be covered under this act. Next important thing that I'm going to talk about is review. We've already talked about it. So in the State Commission, District Commission, National Commission, the power of review is added. Then, in certain rare circumstances, even though the consumer courts did not ever have this format, but in certain rare circumstances, if the court feels, if the commission feels that there is a requirement of a cross-examination, then that cross-examination would also be conducted. Not in all the consumer complaints, I would say, but certain rare situations, even cross-examination would be allowed. Another important thing is you can even get the order implemented from the civil code. Now, this option has been added in the 2019 Act. Other than that, you have to deposit 50% of the decreted amount before filing the appeal. So this option was not there in the 1986 Act, but in the 2019 Act, they have added this option, which means if you're filing an appeal before the State Commission, firstly, you will have to deposit 50% of the amount, which is the decretal amount, and then your appeal would be accepted. Another important thing which has been added in this section is goods. Now, when I say goods earlier meant something which it does not include food. But in this very section, they have included food, which is defined by the Food Safety and Standards Act in section 221 of this very act. So earlier goods did not include food, but the present act includes food also as one of the categories of goods, which means, say, for example, you're ordering something online or you're eating something which turned out to be, say, for example, poisonous. Then in that very situation, even that food would come under the category of goods. Now, one thing that I would talk about is the offenses and the penalties. Now, when I say the offenses and the penalties, I'll quickly cover the how much penalty would be imposed on you in case you're doing a certain thing. So, for example, there is non-compliance of the directions of the central authority. Then there is a minimum imprisonment of 6 months and a fine of 20 lakh rupees. In case you're giving a false advertisement or a misleading advertisement, then there would be a imprisonment up to 2 years or a fine of 10 lakh rupees. And if subsequently the person is again giving a false advertisement, then in that situations, the imprisonment would be 5 years and the fine would be extended up to 50 lakh rupees. Then comes adulterated products. So, for example, the products that have been sold are adulterated. Now, there are again 3 to 4 categories which would come under that. If because of the sale of that adulterated product, no injury has been caused to the complainant, in that very case, the imprisonment would be 6 months and the fine would extend up to 1 lakh rupees. In case the consumer who suffered an injury because of that adulterated product, then in that case, the imprisonment would be 1 year and the fine would extend up to 3 lakh rupees. In case the consumer suffered injury along with grievous hurt, then in that situations, the imprisonment is 7 years followed by fine, which is up to 5 lakh rupees. And in case of death of the consumer, there has to be an imprisonment of more than 7 years followed by fine of 10 lakh rupees. The power of the commission also is there to suspend the license for 2 years. And in case subsequently again that thing happens, then the commission has the power to even cancel the license. So suspension of license followed by the cancellation of license in case of any subsequent action. Then comes spurious goods. If a person is selling spurious goods, again we have 4 categories. One is a person gets injured but there is no hurt. In that case, the imprisonment is 1 year followed by a fine of 3 lakh rupees. In case the consumer suffered an injury which is accompanied by hurt, then the imprisonment would be 7 years and a fine of 5 lakh rupees. And in case of death of the consumer, there has to be a life imprisonment followed by a fine of 10 lakh rupees. Again, commission has the power to suspend the license for 2 years. And in case of subsequent any form of action, the license can also be cancelled. Now, the fourth offence or penalty that we talked about was vexatious search by a Director General. So in case a vexatious search has been carried out by a Director General, then in that case, that Director General is liable to be imprisoned for 1 year and the fine can extend up to 10,000 rupees. So these are the whole things that are covered under the offences and penalties. So all in all, I would say the new act has brought together so many new things when it comes to mediation, when it comes to offences and penalties, when it comes to jurisdiction, when it comes to product liability, that it has completely changed the 1986 Act. And it has to be, because the old Act would not fit in today's world when everything, 80% of the people or say 70% of the people at this moment might be shopping online. So the consumers need to be protected in such situations, in such e-commerce platforms under the new Act. So I've tried to cover most of the things from the previous Act also, from the new Act also, and the amendments which were added in the 2020 Act also. I think I can take up questions right now. So in case you have a question, you can please drop it in the chat. So Anjali, if you're around, can we take up questions from the audience?
All right, now the question.
I've tried to cover most of the topics, but I'd love to see what everybody else has to say. And any questions, Anjali, you can just bring that forward to me.
Yes, ma'am, we do have some questions. Actually, one of the person was asking, HP Store is not giving proper confirmation for the damaged printer or the refund cases. What to do in that case? HP Store is not giving the proper confirmation regarding the damaged products. They are not giving any confirmation regarding the refund or the replacement.
Yeah, so by HP, did you mean HP laptops? That HP company I'm talking about? Okay. Yes. So in case they're not giving any reply, firstly send a consumer notice, right? So you send a notice Hopefully you would get a reply to that notice. In case you feel that you're not satisfied with the reply, then you can proceed with filing a consumer complaint. Keep all the chats, everything that you have, all the conversations that you've had with the company with you, any call logs that you have, they would prove to be beneficial with you. The bills and all sorts of transaction between you and the company, keep them aside, but firstly send them a consumer notice. Because once you send them a notice, they would probably send you a reply. And then if you feel that you're still not satisfied or your problem has not been solved, then you can proceed with a consumer complaint. Yes.
All right, thank you, ma'am. Your next question is by Haran Moser. He's asking, what about the second owner of products?
Second what?
Second owner of products.
I'm not sure what second owner of product meant.
He just wrote about this.
If you can
Or
please
we can
elaborate
have the next question.
to that question in the end. By second owner, do you mean somebody who's in the multi-level transactions? Did you mean the second owner there, or do you mean second owner in some other way? Please elaborate so we can come back to this question then. Yeah.
All right. This next question is, according to you or the Act, who's the consumer under the new Act?
So the consumer stays the same as the consumer in the previous act. The two things that are added is now consumer associations also, which would come under the new act. And secondly, the things that would come under is a consumer who is buying online. So an online purchaser and a consumer association are two things which are now added in the new act. So everything else remains the same. The only thing is when we say we are adding e-commerce to the new act, which means anybody who's purchasing online also would also come within the definition of a consumer.
All right, ma'am. Your next question is, whether bank complaints will come under the same Act?
Whether?
With the bank complaints, are they considered in the same Act?
I don't think the bank complaints would come under the same act. Bank would probably be under the Banking Act. So anything that would come under that would not be a consumer complaint.
All right, thank you, ma'am. Your next question is, if complaint is filed in jurisdiction of complainant, then the respondent will have to go that to the particular jurisdiction?
Please repeat, Anjali. I'm sorry. Yeah, your voice is actually breaking down.
Ma'am, if a complaint is filed in the jurisdiction of the complainant, then respondent will have to go back to the same particular jurisdiction?
Yes, so once you file a complaint in your jurisdiction, then obviously the respondent would have to come within your jurisdiction to get the matter solved or to get the matter proceeded with. So it is now on the onus is on the where you file the complaint. So once you file the complaint within your jurisdiction, so the opposite party might be residing somewhere else, but you might have filed a complaint in the where you reside or where you're personally working for gain. So once you file a complaint there, the opposite party would have to, the respondent would have to come to your city and then get the matter resolved or to proceed with the complaint.
Thank you very much, ma'am. And your next question is, what if a person buys something from railway station or the trains and the product is already damaged? What to do with that case?
So again,
What's the remedy?
So again, you can file a consumer complaint in that case or for a damaged product. Or say, for example, if the product which is sold by the railways is actually manufactured by a different company, you can proceed against that company as well. So say, sometimes when we are traveling, we might have a product which mentions that a different manufacturer has made it. Obviously, they might be outsourcing it from somewhere else. So either you can file the complaint with the railways or you can even proceed under the Consumer Act as a consumer against the manufacturer.
All right. And the next question is, if a telecom service provider is not able to provide the good services after complaining so many times, can we file in consumer court?
Yes, you can definitely file. But as I told in the HP thing also, once you send a notice to the opposite party, it kinds of strengthens your base when you file a consumer complaint. Because the opposite party would somehow be bound to reply to your notice. And once you get a reply and you still feel that the notice was not solving the purpose and the reply again did not solve any purpose, then you are well within your rights to proceed towards the district commission or the national or the state commission. So I think for anybody who's asking me any questions about the complaints, I think the best would be to firstly get the notice sent Wait for the reply. Once you get the reply, if you're not satisfied, then you can get going.
And ma'am, with respect to the same part, one of the person is asking, is notice mandatory before complaint?
No, I think notice is not mandatory, but you still should send a notice before you file a complaint, because again, I just said how it works when you send a notice. So when you get a reply, probably your problem might just get solved before you move a consumer complaint, because most of the times what happens is when you send a notice, it kinds of shows a path to the opposite party that you might proceed by filing a consumer complaint. So at times they might just solve the problem before you have to go through the hassle of filing a consumer complaint. So notice is beneficial and important in that ways.
All right. The next question is, the company is foreign, then they might be time lapsed.
There might be time lapse.
Time lapsed. If the company is a foreign company.
Yeah. So there might be time lapse.
The question is written like this only. The company is foreign, then they might be time lapsed.
Time lapse for what? If you can just elaborate that point, then I can probably be in a better position to answer that question.
This is as per location, actually.
As per location.
Ma'am, the same question was asked by location, ma'am. So I am actually requesting you to tell him that he can elaborate the things in the comment section, so we can tell him the things.
Yeah, and then I can get back to that.
Your next question is, ma'am, what are the remedies when we go to actually cinema halls and we tend to get the things on the double rate? Where should we go?
See, now when it comes to double rate, right? A manufacturer or a service provider is well within its right to fix any price for that product. It is on the consumer whether they want to buy that product or do not buy the product. So charging double the price I would not call it an unfair trade practice or a restrictive trade practice. It is well within their rights to charge something they want to. Yes, if you feel that post giving a certain price, when they're delivering the product, they've charged something which is different, then you're well within your right to take an action against them. But if you feel that they've charged something which make no sense, the manufacturer is still within their right to charge for that product, right?
Yes. Actually, your next question is, what is illegal trade practice?
So there are two forms of trade practices which comes under the Consumer Act. One is the restrictive trade practice, and the second is the unfair trade practice. When I say restrictive trade practice, it would be regarding things like delivery and pricing. So if you feel any of the two things are not right, then they would be called as restrictive trade practice. When I talk about unfair trade practice, say for example, an advertisement is misleading or a representation has been made. You see a product as something else, but when the product gets delivered to you, it comes to be something else. Or you see something else in the advertisement which is false and misleading, then those things comes under the unfair trade practice. So restrictive trade practice can be also an illegal trade practice, and the second one is unfair trade practice.
And one of the person is asking, there is no need of lawyers as it's not like the actual codes. Then how could the person send the notice?
You definitely need a lawyer to send a notice. That is for there. If you would be proceeding that way, so you would need a lawyer who would file a notice for you, send the notice, take the notice, and the same lawyer might want to proceed. You might want to use the same lawyer to proceed for the consumer complaint as well.
All right, ma'am. Your next question is, will this have a retrospective or prospective?
The act.
What if the cause occurred before the date of enforcement?
Before the
enforcement.
Will it have a retrospective effect?
Can I repeat the question?
Yes, please.
Will this have retrospective or prospective? What if the cause occurred before the date of enforcement of the act?
As far as the date of enforcement is concerned, I'm not very sure about what effect it would have there. I'll have to check, and I think then I can get back to you. But I think this question is not within the scope of today's topic. So I think I might skip this question.
Yeah. All right, ma'am. Your next question is, charging more important than MRP, wouldn't that be violative?
Anjali, sorry, if you can repeat your question, please.
Ma'am, charging is more important than MRP. And don't you think would that be violative?
See, it is violative, but charging. Yeah. If your question was in the previous question also, if they are charging more than MRP, then that is restrictive trade practice. By the previous question, if you meant that a certain company is charging 50 rupees for a product and another company is charging 100 rupees for a product, if that is what you meant in the previous question, then that is not a illegal trade practice according to me. But if your question states that MRP of a product is 50 and the other company is charging 100, then that is definitely a restrictive trade practice. So these are two separate questions in my eye and in the eyes of law, if whether two companies are charging differently for the same product or whether they are charging above the MRP. So I think if that answers my question.
Ma'am, actually, I was asking with respect to like at one place, the actual price, the genuine price is 200, but the
Mhm.
other cinema hall that is selling the things on approximately 700, 800. That's what I'm asking.
Yeah, so they can still do that. That is up to them, up to the consumers whether they want to use the service or not. Yeah, but if they're charging something which is above the MRP, then that falls within the restrictive trade practice. But if one cinema hall is charging 200 for a ticket and another cinema hall is charging 700 for the ticket, then you might as well go to the place which is charging 200, but you cannot proceed against them saying that why they're charging 700 for that service.
Yes, ma'am. Your next question is, how do we provide evidence for food products which get spoiled? How to prove it?
That is what I talked about when I talked about the district commission. So if now that food is included in goods, what you can do is you have to take a sample, send the sample when you file a complaint. The sample has to be sent to the laboratory for testing. So that you another way of doing that is even you can send the sample to the laboratory, and when you file the consumer complaint, you can attach the testings that have been done by the laboratory to that food product, because obviously when it comes to food you cannot wait for the complaint to proceed and then you keep the food and then you would get it tested. So you get the food tested. Once you find out that the food was adulterated or the food was not up to the mark or it was poisonous, then you can attach that the food testing, the reports of the same with your consumer complaint, and then you can proceed with it as an evidence. So you can use it that phase.
All right. Now, my next question is, will commercial users be included in the definition of consumers?
Yes, of course.
All right, ma'am. Your next question is, what does law says for the malpractices constantly practiced in the rural areas, as mostly the people in such regions are illiterate?
See, again, they say is you need to know your own law. So even if you feel there are certain malpractices in the rural areas, again, as a person who's in the rural area also would fall within the definition of a consumer. So if you feel there has been certain malpractice in your area, again, the procedure would apply the same for somebody who's in an urban area or somebody who's in a rural area, right? So know your law, know your rights, know your privileges. And this act has been, in fact, I would say so hyped up since 2019. And now that it has come in force on 20th of July, I see so many websites talking about it, because this is one thing that's not just covered under the prospect of law. I would say that it's not something that lawyers would talk about or the law students would talk about. This is something each and every person should know as their own right. So that applies to urban people also, rural people also, and the procedure would still say the same, for the rural also. What can happen is there should be, I think, more consumer awareness programs in the rural areas, because initiating such programs in the rural areas would at least make them aware of their rights, not just the consumer rights. I'm sure there are a million other things that would come, but there should be certain programs which should be started by the government so that they know about their rights and the liabilities of the sellers or the manufacturers.
Ma'am, your next question, and it might be good, the last question. We won't take much of your time. Your
In
last
fact,
question is, if we can prove that same quality product have different MRP, still we can sue the person who charge more.
if
Now, what if we prove that the same quality product have different MRP, still we can't sue the person on who charge more?
so now see, you buy a soap from the market. One company must be having an MRP of rupees 30 for that soap. But you buy a very expensive product from, for example, an imported company who might be charging 500 for a soap. Both are both are solving the same purpose, but you cannot just go and file a complaint because one company says this product is for 30 and the other is charging 500 for it. So when I say MRP or when I talk about MRP, the same line of products could have different MRPs. And one company charging a lesser MRP and another company charging a more MRP would not make it a illegal trade practice or a restrictive trade practice. So for me, I would not say for me, according to law, a restrictive trade practice is if they are charging above the MRP. For example, the printed price on the product is 20 and the shopkeeper is selling you for 50, that is the pricing comes into the role play of pricing comes, right? But you cannot compare two different products for different MRPs. They are well within their rights to charge anything they want to.
Ma'am, one more question.
Yeah, definitely.
Actually, when there are two operators in a sale, like Swiggy and a restaurant, liability will be on which operator?
One is Swiggy and the other is?
The restaurant.
Okay. And the liability for the food?
The liability will be on which operator?
For the food.
Yeah.
So by food, do you mean the food quality, or if, say, for example, the food has not been delivered properly? See, now, if the food is delivered to you, but say the food has come in a not has the food has spilled on the way, or the food has been eaten by a delivery boy on the way. So the liability would obviously be on Swiggy. But say, for example, the food quality is not fine, the food packaging was not fine, the food contents were not fine, you ordered something else and you got something else, in that case, the liability would be of the restaurant. But say, for example, something that happened during the transition process from the restaurant to the home, or something that happened during ordering the food through that app. If ordering is your question, then I think any disputes relating to ordering of the food would fall within the purview of Swiggy, and anything about the food quality, food contents would fall within the restaurant. So that's how it is.
With this, our question and answer round comes to an end. And I would like to thank Ms. Advocate Bhavna for such an informative session and for sparing time from her busy schedule.
Thank you so
Thank
much.
you so much, ma'am.
Thank you for having me.
And the link for downloading the e-certificates is available on our website. Ma'am, you want to say something?
No, I'm just saying I'm glad I could pick up this topic because I think the rest of everything you can just study from the book. You can still do it for this act as well. But this is something I think is so informative and so educative for every sort of people that I'm glad I picked up this topic, and I hope I'm able to impart something from this to all our viewers and everybody who would be watching this later. So thank you for having me.
And the last thing I would like to tell you is the link for the downloading e-certificate will be available on 23rd of September. Thank you so much. And with this, we'll wrap our session. Thank you so much.
Thank you.